Okay, everybody, let's go ahead and get started. Thank you so much for coming out today. We are really excited to have a guest speaker today, Professor Victoria Nourse from Georgetown, who is going to be talking about originalism and textualism, and why we should care about this topic and sort of what's going on. So clearly something that is important today. I think one of the things that I really appreciate about Professor Nourse's work, and she has an article that came out, this talk today is reclaiming the constitutional text from originalism. And when we think about the text, right, and how originalists use text, I found really interesting. I'm looking forward to your talk about her selection, asking questions like, what text do we use if we're going to be textualists, right? What words do we choose? What's the context of the words around that text that are not being referenced? And what's the larger context, meaning how does that text fit into the entire Constitution? And what impact does that have on executive power? So obviously these are really important questions that we're grappling with when we think about executive power and we think about the use of originalism and textualism in understanding the scope of executive power. So I'm thrilled to have our speaker here today to share her thoughts. I also want to remind you that the Byron White Center is putting this on with the American Constitution Society, so we're really grateful. Thank you so much. We're excited to co-sponsor this event. I'm Suzette Malveaux. I'm the director of the Byron White Center for the Study of American Constitutional Law. And want to just flag for you really quickly some of the things that are coming up down the pipe that you may be interested in. So after this talk, we have another talk next week where we have Professor Brian Fitzpatrick, who is a Vanderbilt law professor, is going to be talking about the conservative case for class actions. So I'll have an opportunity to discuss or wrestle, I don't know which way that's going to go, but we're going to be talking about class actions, and that's one of my loves, actually, one of the things that I've been thinking and writing a lot about over the years. But I'm looking forward to doing that, and we are going to co-sponsor that with the Federalist Society. So we're excited about that event. Fast forward in April, we are encouraging folks to come out to two events. One is AI and bias. So when we think about generative AI and the impact it's having on society, we want to be sure that we are not missing anything. So we will be having a panel discussion with a number of experts who will talk about AI and bias on April 18th. It's a lunch talk. And April 19th, we have an entire conference that we are co-sponsoring with the Silicon Flatiron Center. Not only are they co-sponsoring the AI and bias lunch talk, but we're going to be talking about AI and the Constitution more broadly and all the kinds of implications, constitutionally speaking, that AI raises for us. So we encourage people to keep us on your radar screen and continue coming out for these events and important conversations. I think at this point, I would like to have M.R. Dickey, who is the representative from the American Constitution Society, come and introduce our speaker. She is a 1L, so we are thrilled to have 1L involvement. So if you're excited about this kind of work, please come and join us. So M.R., please join us. Thank you.
Hey everybody, if you don't know me, my name's M.R. Dickey. I'm currently the social media director for ACS, but I'll actually be the incoming president next year. And I'm very honored to be introducing our speaker for today. She has worked for the federal government in several capacities, including Chief Counsel for the former Vice President Biden in 2015 and 2016. She's actually now been recently appointed to be a U.S. Commissioner for the Commission on Civil Rights, which is, I think, fascinating work. In addition to her civil service, she's advocated for all kinds of legislation, including the Violence Against Women Act, which passed in the early 2000s. She has also taught at prestigious law schools such as Georgetown, Northwestern, and Yale. Beyond all of this work, however, she is most known for her work on statutory interpretation as it applies to the separation of powers. Today, she'll be presenting her work on originalism and how it has perverted our country's realization of many civil liberties, our own framers actually prize. She advocates for greater scrutiny when it comes to the use of originalism and textualism, finding that most who call themselves originalists or textualists do not base their interpretation solely on the text itself, but rather add their own subjective meaning. Specifically, she takes issue with how these interpretive theories have been used to expand presidential power beyond its constitutional bounds. So, if you all will please join me in giving a warm welcome and applause to Professor Victoria Nourse.
All right, I'm going to turn on the microphone, but thank you so much to the Byron White Center and to Professor Suzette Malveaux and my friend Jim Anaya, former dean, professor extraordinaire. I'm so happy to be here. I've never been to Boulder. My daughter went to another school, but I learned to love Colorado. And I've never been here, and it's great to be here. So you heard two different themes, one about executive power and one about civil rights, and I will attempt to bring them together. I just want to say one thing. I am the vice chair of the United States Civil Rights Commission, and I am not speaking in that capacity at all. These are my own personal views as an academic. They do not represent the views of the commission in any way, shape, or form, particularly since two of the members were nominated by a former occupant of the office. So, I don't want to speak for them. Now, and by the way, we just had a hearing on facial recognition technology, and we're moving into AI, so I can't wait to hear what you are doing, because it's going to take a whole country to deal with that. All right, originalism, what is it? Well, it's really a Supreme Court idea, and it's a Supreme Court idea about the Constitution that I think is incorrect. But let's take a look at this picture up here. It's of what they used to call in the 30s the Marble Palace. This is the entrance to the Supreme Court, right across the street from where I teach, and that seems all cool, but Harlan Fiske Stone, who was a wonderful justice, a Chief Justice, said that this was just unbelievably pretentious. And he didn't really like it. Even the justices early on didn't want to go into this building, and they preferred, like granddads, to stay at home with their clerks. But pretentiousness may suggest something. I just saw at the Boulder Bookstore a book by Aaron Tang, who teaches out on the West Coast somewhere, and he's talked about the arrogance of the court. And I think this visual might suggest there's a certain kind of arrogance, both about the text. And you'll see why I think that is true, because I think their idea of the Constitution is focused on themselves, on the court, on a juridical constitution, not a constitution of self-governance, a constitution for the people. And I do believe that ultimately that poses some pretty serious dangers. So if I go too long, Professor Malveaux, you'll just come up and take me off this stage and we'll move to the conversation. All right. Why does it matter? Well, this was sort of a slide I did today about racial reconciliation. Some people call it affirmative action. I don't like that word. Abortion and guns. Yes, here comes the gun. I know, we're in Colorado, people like their guns. But what has happened here since originalism has taken hold through Justice Scalia is a reversal of what people considered to be appropriate rights when I went to law school. So my vintage is actually an advantage here, because I can tell you how much it feels to me that things have been changing rather rapidly. But I am an academic, and I like to not just say things, I like to try to prove them. And so I joined up, and I've helped create something called the Supreme Court Interpretation Lab at Georgetown, along with Professor Anita Krishna Kumar, Professor Kevin Tobia, and Professor Neil Sukhatme. Sukhatme is an economist and a data nerd and a coder. Tobia, who recently received tenure, is an empirical philosopher. You didn't even know that existed, right? It's sort of like high-profile data meets philosophy meets sociology. All right. So we all came together to try to understand whether originalism was new or old. Because to me, having studied law, I think, Professor Anaya might be able to raise his hand on this one. When I went to law school, there was no talk of originalism. And yeah, I'm old, but not that old. And so the question is, the research question, and the only reason I use this is that I was looking for a picture of the founders that I could easily download, and this is what came up. A war game. Now, it's World War II. I get that. Everyone has some interest in World War II. I, too, wrote a book that actually was about a case decided in 1942. But it was odd. So I want you to just put a little check mark by this, because we're going to come back at the end to this. So So we had an empirical hypothesis. A Supreme Court opinion is more originalist the more it cites historical resources. This is one definition originalists use. Now, if my colleague Randy Barnett were in here, or some other colleagues I know who are originalists, they might disagree with this definition, and we recognize that. But at the very least, this was our hypothesis, okay? We recognize that there are many different forms of originalism, but we decided, well, the main thing is about going back to the founders, going back to the meaning of 1787 or 1865 when the 14th Amendment was passed. So let's try to test that, at a minimum, as a beginning project for our lab. So we built, well, Professor Sukhotme built, a very large database. All U.S. Supreme Court opinions on Westlaw, 1980, 2021, it just goes on and on and on and on and on. A lot. It is the biggest database ever built on Supreme Court text, including treatises, oral arguments, briefs, and it's all public, but now it's in our little interpretation lab, and we are going to be running a series of experiments, testing more hypotheses as we move forward, which is one reason I'm here, running around the country. I was just in Oklahoma, and to tell people about this, because I think it's an important, and I hope it to be a collaborative project. This is not all about Georgetown. This is a collaborative project because I expect the big data is really going to transform how we do textual analysis. All right, so we built the database, and these are the kind of sources we looked at, and you can imagine, well, these are obvious, and we took them from a series of articles by a judge who sought to define, in a series of articles, Greg Meggs, what were founding era sources. So Federalist Papers, Articles of Confederation, their founding era dictionaries, treatises, case law. The founders actually loved treatises, and they loved foreign treatises, like Pufendorf and Grotius. Oh my gosh, who knew? State ratification debates, which is the core of one form of originalism. But as you see, it's very capacious in its coverage. So to validate our prediction, we used this hypothesis and tested against the modern court, okay? Just the modern period. And what we came up with was this. So you might not be able to read it, but we're just trying to test if we could find the justices who were most likely to be originalists, and this was a test of just a small period of a larger database, and it seemed to confirm our hypothesis. We have Gorsuch and Barrett and Thomas and Roberts and Scalia. A lot of people don't think Roberts is an originalist, but that's because they only read one or two opinions. Law school is relentlessly anecdotal, and I've had a big fight with my co-author, Bill Eskridge at Yale, on this. But in any event, this was just a test of the system. A test of the system. So here's what we're trying to hone in on. Justice Scalia and Attorney General Meese once said in different places at different times that originalism was orthodoxy. They told a story about how the Warren Court abandoned this, and that they were going to revive it because it was the tradition. It was orthodoxy, to use his word. And so we decided, well, let's try to see over time whether that's true. And this is we have a lot of fancy graphs in here, but what you can see is that in 1971 with Bork, 1986 Scalia, and mostly into the early 2000s, the increase of the cases with the most historical sources. There are some outliers. Dred Scott, yes, it was an originalist case. People debate that, but I disagree. Myers, which is an extremely long opinion about executive power. Passenger cases, which no one remembers anymore, but it was about whether states could admit certain people coming in at ports, and the opinion was seriatim. So each of the justices issued an opinion. All right. Then we did it with respect to references to founding father framers or framers of the Constitution, and again the pattern appears. All right? Then we did it with Supreme Court briefs, oral argument transcripts, and again the pattern appears, to the extent that it is not consistent over time, which is exactly what we're trying to test. Then we did a regression analysis. So you could explain this, like the passenger cases, because they're really long opinions. Some Myers is really long. Dred Scott is really long. You could say it's just the word count in the case. It's the case citations, the number, the density of citations, the number of Supreme Court clerks per year, because those have increased. They have more capacity to write more. And just an annual time trend that it would increase slowly over time in any event. And none of them, individually or together, would predict what we found. So we have done our best to try to do our due diligence to show that this is not as consistent a pattern as implied by the story presented by Justice Scalia and Attorney General Meese. Now, there's some things we cannot say, and I'll talk about that in a second. We cannot say anything about the period right now from 1800 to about 1830 because they were the founders. They knew about the founders. They didn't have to cite the founders because they were. So we have more work to do there. We also have more work to add the 14th Amendment. We expect this to follow the same trend, however, because the 14th Amendment only does more work when it is, applied to the states, and it isn't applied to the states for a very, very long period of time for our constitutional history. Sporadically through the 20th century, very early 20s, 30s, but mostly 60s, 70s. But what it does show is, the bottom line is, it starts in the 1970s, it accelerates post-1986, and really accelerates in recent years. If you look at these charts, you'll see, it's very, very high on, the last end, and it gets higher. I wish I could spread this out a little bit more from 2000 to 2023, but that was kind of shocking to us, but not if you realize that the most originalist justices are the ones now on the court. Well, defining originalism as we have done. All right. So these are our takeaways. So it seems like it may be that originalism is not about remembrance, but forgetting. That we are forgetting. Whether it's a good thing now, maybe, that may be what people think. I'm not arguing the normativity of it right now. I will in a second. But right now I'm just trying to understand the historical claim. Because if it really had a long provenance, a real tradition, it's something you've used over and over again, it's become ingrained a norm, and it does not seem to be that way. And if you read historians of all these periods, I myself have written about Lochner and other cases, you'll see that they didn't involve the same kind of concepts we use today. The idea of a strong right did not exist. A right could be undone basically by health, welfare, other things. So our jurisprudence has changed, and my worry is that we're forgetting both the good and the bad, right? Because we need to learn from our failures as much as our successes. I believe that originalists valorize both the text in the way they see it, as well as our history, but there's some really bad things that have happened in our history, right? Look at some of those opinions, Dred Scott. Really? Do we really want to be going back there? And so I don't think, I'm worried about this, and we're going to continue to refine that, and I hope that you follow us. But I want to bring us back before our one-on-one to talk a little bit about originalism and violence. Professor and I asked me, well, I've got to fly in to see him, I've got to go to DCA, and I only live 5 minutes from DCA. And he said, I thought you lived on Capitol Hill. And yeah, I used to, but then an insurrection walked right by my house, and they cordoned off the block. I have never had a sadder day in my life. I got an internship on Capitol Hill in the House of Representatives when I was 16 years old. All I wanted to do as a kid was do something no women did. And I saw Barbara Jordan at the Watergate hearings when I was, I watched tapes of that. And I just thought, wow, we can do this. So it was really, really sad. And I worried a lot as an academic about the relationship between originalism and violence. And I don't know if this would, this might have been just my bad click of a day. But the first civil right, if you're worried about civil rights today, the first civil right is peace. Without peace, we have no other rights. And query why originalism is coded by the internet in this by, with violence. That would be an interesting research project for you all. But I do worry also because the person who actually developed the legal theory for the insurrection, his name is John Eastman. He's in the right now. I think he's being disbarred in D.C. But it was a legal theory. Now he was on Team Crazy, not Team Normal. If you watch the January 6th hearings, but he believed that he could just skip over the Electoral Count Act and go to the Constitution. And his originalist theory was that the vice president could count the electoral votes and decide in his favor. Would suggest to you that there's very little restraint in this method. It looks precise, but in fact it may be just the opposite. It looks unbiased, but it may be the opposite. So finally, I'm going to leave you with my idea about why I think originalism as a normative matter and as a theory is an incorrect theory of our Constitution. We have really two constitutions, or at least two audiences for our Constitution in one document. Originalism is a theory for courts. It's not a theory of the Constitution, because courts are only one part of a much bigger governance structure. We have a president, we have Congress, and the courts are really rather small. You know, if you really want to get under their skin, take away their clerks, turn off the air conditioning. Congress has the power to do all that, right? They don't have an army. And we in law school revere courts. I was once nominated by President Obama to be a judge. I revere courts. I am not one to say it's all just politics. I push back against this. I believe in the rule of law. But the rule of law is not all of the Constitution. It is a part of it. And I think courts have been confusing the part that they inhabit with the rest of the Constitution. So they focus in on their role and how they read it like a statute. And what they forget is that the Constitution is performed every time we peacefully vote, every time you elect a member of the House, every time we elect a president. There are performative aspects of governance that are actually the most of the text comprise. They wanted to create a government that didn't exist. That is the most important thing about the founding. It's not the court. The court sat in the basement of the Senate in the Capitol for years. That is the most important part. And the problem is that originalism, unfortunately, has forgotten that part of the Constitution. There is a silver lining here, though, which is to say that if you don't like where originalism has taken executive power, which has been to expand it, to focus on a part rather than the whole, I could talk more about that if you want in questions. If you worry about the civil rights that we, seem like everyone had when I went to law school and things have changed so radically, I think you do have to worry about originalism, but you also have to respond to originalists that they're only describing a constitution for courts, not for the people, not for we the people. We the people are the most important part of that constitution. And we the people vote every 2 and 4 years and make our opinion known. And as part of that, I think we need to reinvigorate not so much our worry about rights, not so much our worry about powers, but our legal understanding of democracy as the most important part of our Constitution. So thank you. I am going to... Sorry if I went over, ladies.
No, you are totally fine. Okay, I apologize. I should have mentioned that the next piece of our conversation, we are doing a fireside chat between Michaela Calhoun and Professor Nourse. Michaela has been a fellow with the White Center for the last 2 years, so she's a senior fellow getting ready to graduate. Very excited about that. And is a 3L and former president of BOLSA and one of our extraordinary students here. So I'm going to give them a chance to do a Q&A together, and then we'll open it up to the general audience for questions. Okay.
Okay. Well, thank you so much for that talk. I truly enjoyed it. It's nice to see statistics behind originalism. I think in all of our classes we hear about this is originalism used, but don't see the impacts. So I want to ask you, besides in the case of executive power, where have we seen originalism or textualism, textual gerrymandering, as you put in your article, play in court opinions?
Well, I mean, the most obvious one to people who read the newspapers is jobs and abortion, because the court used, there was, I knew that originalism might actually be a topic I could give a speech about till it normal human beings, sorry, like my sisters, when Saturday Night Live had a spoof where they had Benedict Cumberbatch went back in time to the 13th century and developed moral clarity about everything in a state where people were dying of plague and they had no fresh water and, you know, they were all serfs and, you know, whatever. It was a pretty bad time in the 13th century. So they went back to that, and Justice Alito has been, you know, reviled for that. But it's not the only case. You saw the little gun coming up there. When I went to law school, there was no right to bear arms except as part of a militia. The first part of the Second Amendment has been receded into the past, textual gerrymandering, you know, the militia part, the clause. A lot of, if you read Heller, you'll see that a lot, because there's a lot of discussion about preface and all that kind of stuff, preambles. But there's other cases. In fact, increasingly since 2019, the cases are predominantly originalist. So recently there was a case by the Fourth Amendment. And it is one of the top originalist cases, Torres, in our list. I don't know if I gave you the whole list. But it's a debate between Justice Roberts and Justice Gorsuch about the meaning of a search, again, a long, long time ago. Using a lot of historical sources, common law arguments about what amounted to breaking and entering and debtors and a whole bunch of things. And it's a very long opinion. It's one of the top originalist opinions. So it's everywhere. Do not assume it's just in the few cases that you read. It is also, and this I didn't mention, but I think is more important. I don't know how I'm going to study this, but originalists will tell you they don't believe in precedent in the way judges did when I went to law school, which is to say, originalism is really an attack on the Warren Court and, you know, sort of forget it. So what the problem is, it's not only that you may not read, you might read a lot of Warren Court decisions in criminal procedure, but you must see that it's all changing, right? So when I have a piece that has yet to come out from Constitutional Commentary, which is a peer-reviewed journal, so I like to be very precise and careful, but because it's such a long piece, it's taken almost 2 years. It's on SSRN, but basically I'm reading every case that they issue because I believe that 2019 was a sharp break from the past. And I believe I'll be able to show it with increasing data and a just relentless focus on, it's only 60 cases, people, on what they are doing now. And when you read that, you really realize that it's not just the headline cases. So civil procedure, I mean, I'm trying to hold a conference at Georgetown where I get people in to study the disruptive effects of this, because Adrian Vermeule's a conservative at Harvard, has written a book called Common Good Constitutionalism. I don't agree with that book. However, I do agree with his claim that originalism is primarily disruptive because it seeks to overturn precedent. It seeks to leave, it's kind of an atavistic throwback kind of thing, which means you've got to get rid of what was in the middle. So I wouldn't think that there's any area that is free from originalist influence today, potentially. That's why when I go to law firms that are right around where I teach, and you know, some of them are heavily originalist law firms, they smile a lot when I say, this is a full employment bill for lawyers, because it is. The same thing with statutory interpretation, which is more of what the court does. The court does 10 to 15 Supreme Court, you know, constitutional decisions a year. Most of what it does is statutory interpretation. A few procedural things. But less so. And there, true, if you've decided something based on legislative history, you might be able to go back and say the text. But that is a long answer to a short question, so I can shut up.
No, we love to listen. And even more so, going into the current SCOTUS term, I'm thinking about the recent cases in regards to presidential immunity and states' power in administering elections.
Colorado, I'm so sorry.
What are your thoughts in regards to the originalist interpretation in regards to that?
And thank you again for bringing me back to that, because Professor Melvo and I have been trying to get together to talk about this for a long time. The court has been building up a very strong theory of executive power, so strong that some of the people trying to be disbarred for the insurrection claim they can't be disbarred because, in fact, they were acting in the administration as if Article 2 insulated them. The court has been going down that road, and but originalism is also not consistent. So I just taught the disqualification cases. I have a seminar called Supreme Court Now and Method, because if I just taught method, everyone would fall asleep. So this time I've never given a credit, it's a 2-credit course, so they write short papers. I gave the paper on the disqualification case to give a structural argument, because I said that was what they were gonna do. I'll talk about that in a second. And 3 weeks later, we had the decision. That has never happened before. So, it's not consistent because a lot of people thought the originalists were all arguing about whether the president was an officer of the United States. They hone in on one word, whether it's an investing clause like the meaning of executive, or the meaning of legislative, here, officer, and they really just, they turn it around, and if you know anything about linguistics, when you pull a word out of a context, you're giving it a new context, basically a null context, an empty context, and that's why originalism and textualism are at war with themselves theoretically. They would not say that they are taking words out of context, but that's in fact what they do. And when they take it out, I think, I can't prove this, but maybe I'll find some linguists who can help me do this. I think they have a much more likely to add their own meaning. They increase the risk of bias rather than reducing the risk of bias. And so I'm going to try to test that. But linguists don't read sentences that way. They read the whole sentence, for example. They don't pull words out. Lexicographers are what Justice Scalia relied on. They're the dictionary builders, and the court loves dictionaries. But that's a different debate. And there's all sorts of problems with dictionaries, but I digress. Okay, immunity and disqualification. Disqualification, it was no surprise it was a structural argument. That was the assignment I gave my students. Why? I've studied structure for a really long time, like 30 years. And I really didn't think that if the Constitution said office of the president 20 times, that they were going to get by saying he wasn't an officer, okay? It just made no common sense. So they're not crazy, right? They haven't left common sense at the door. That's what Justice Scalia said. I'm an originalist, but I'm not crazy. And so what they were left with is a very old traditional argument, McCulloch versus Maryland, that a state can't impose rules on the federal government that impairs the relationship of the citizens to the federal government. This was not because I totally agree with Colorado, personally. I agree with that decision. I don't agree with the court moving it all the way to having a congressional statute. They didn't need to decide that. And Amy Coney Barrett, who's moving, she's going to be justice. She's moving toward the middle of the court. She said you didn't need to decide that. So they overreached, but it was predictable that they wouldn't actually decide that based on a word, in my opinion. So originalism doesn't always get them what they want it to go, and it's not necessarily consistent. Now, what about the immunity? All right, I'm getting in trouble for predicting things, but I've been right on this. So I will predict that they will come down against Trump on the immunity because the case law is they would have to overrule essentially pieces of their cases or at least distinguish them in technical ways that the public could not understand. They understand that the public is their audience, that this needs to be accessible to Supreme Court reporters and law professors because the country is nervous. I was over in Oklahoma and I started to end up, because I worked in, for the current president, they were asking me about things and people are scared and they should be. But I think it's a wake-up call, One good news is the court has not ruled for Trump consistently, and they haven't said we're Republican or we're Trumpists or whatever. They have hewed to what is within the range of acceptable argument, even if new and newly constructed. And so I think they will hold that he is immune from official acts, but not non-official acts. And then the question will be, even though the DC Circuit has held what happened was non-official because it was built by, and there's a reason why they can do that, and I could explain that if you wanted, but they might send it back to the trial court to determine that, and that would be delay. And one of the reasons that I'm not happy with the court right now is they should have decided this. There's an easy one-page opinion based on the Nixon cases. And the DC Circuit did a fine job. No one really thinks that the president can have, SEAL Team 6 kill his political opponent, as Judge Pan on the DC Circuit. And she's never gonna live that down, that hypo down. But it was important. So I expect the immunity case to come. Will it be an originalist opinion? There is no text on immunity. And, there are scholars, Sai Prakash has said there's no executive privilege in the Constitution, so he doesn't think it's there. And one might say they view that it's appropriate to have something called a rule of negative implication, which is, it's an old canon in statutory interpretation, but basically, if it's not included, it's excluded. If there's no right to abortion, it's excluded. That's not what the Constitution says. Look at the language about the rights reserved to the people. But that's the implication in Dobbs, and you could say that immunity, a textualist could say that. The reason I don't think they'll go that far is because of the existing precedent. And they'll marry them. There's one that says the president is immune from official acts. That's Harlow versus Fitzgerald. And then the other one is the Nixon case saying, no, he can be, at least he was an unindicted co-conspirator, and therefore he is not immune from a criminal proceeding in that sense. On the other hand, I didn't expect them to say that Congress had to pass a statute to impose the amendment, disqualification amendment. So they're not shy. So I'm losing a little bit of, I was very confident before that opinion, and I'm losing a little bit of hope, particularly because of the question presented. Because the question they agreed to hear was on official acts and non-official acts. And that could be a real practical problem for Jack Smith and his prosecution.
Okay, one last question, and then I'll open it up to the audience. With the increased use of originalism, and as all of us going to be lawyers soon and practicing in front of most likely originalist judges, what are some alternative methods of interpretation that we can use in our briefs and in oral arguments?
Well, first of all, the judges stay on the bench for a really long time. You know, they're kind of like nuns. They stay there for a long time. They're one of the most, they study longevity. Being a judge is a really good thing. I think law professors too. Right, Professor Nye? Law professors. Well, we have a canon law expert who is a former priest in Hungary. He was a political opponent of the regime, and he's 99. So my dean and I are like, how far can we get to 99? No, I'm teasing. I wouldn't expect that all the judges are textualists or originalists, but they're increasingly becoming textualists, so you have to start with text. Never start with legislative evidence. I don't call it history, it's not really history, it's evidence of meaning. To your history, I mean, there are whole groups of people now developing think tanks with historians. I don't think historians are really going to help you because originalists say it's not history. What it is history of text, which is different, and history of law. And people are developing databases. There's an institute at Duke that's doing it on firearms law. They've developed all the history of firearms law. So you have to do the history, but please don't be frightened of pushing back. Because also pushing back on their text choice. I've been saying this for a long time, maybe 10 years. They pick and choose text. They're not very good textualists. And Justice Sotomayor recently in the Loper-Bright, this is the Chevron case argument, she mentioned gerrymandering and someone pushed her on that. She said, oh, it's a law professor idea. Like that was a bad idea. But it gives you a sense of what's wrong. So in one word, you could say, no, you're picking and choosing the text in a way that's outcome determinative. So you can use these things. You know, there are tools for pushing back. Because often, if you look at my article on gerrymandering, we showed how the court was not correct in the text. They disagree with each other on the text all the time. If you think that the other side has only a textual argument, you're wrong. Why? Almost every text has two meanings. One is a prototypical meaning, meaning the core, so no vehicles in the park. Vehicle could mean what? A car, right? The thing that comes to your mind. But it could mean, well, maybe a bicycle, tricycle, wheelbarrow, right? So that's called prototypical and extensive meaning, and you can do that too in almost any case. Also push back on the method too, because they're in hot water. In this new case, Rahimi, that involves the Second Amendment right to bear arms and domestic violence, I was asked to do a conference at Notre Dame on the new test, and the new test is history and tradition. Originalists, by the way, think that might be different than originalism, so buckle your seatbelt, because they're fighting amongst themselves about this. But, so what level of generality did you ascribe the tradition? Which one are you, the right, the conduct? And this was raised in an article by Reva Siegel, and she wrote a brief, and Justice Gorsuch started talking about it. So you can push back. And you don't need to push back using the words they hate. I mean, they have some words they don't like. They don't like legislative history. They don't like policy. They're self-hating consequentialists, in my view. They say they don't look at consequences, but in fact they do. Look at the disqualification case. What was that? It was a pragmatic decision so that, we wouldn't have a divided election for a federal election. That was what it was. So there are ways to push back. I don't know, maybe I should put them all online for you. How to push back. I've been thinking of doing an anti-originalism blog, but I don't know, it's nervous making in Washington these days because, people get really mad at you.
Well, thank you so much. I'm now going to open it up to everyone in the audience. If you guys would like to ask questions, please feel free to raise your hand and we will call on you.
Can you all hear me, or should I?
Yeah. All right.
Oh no, you're gonna give the mic to them. Okay, good.
I can project.
Okay. I'll recount for everyone.
So
Yes, good.
on the topic of pushing back, how do you suggest that we approach the truly kind of dangerous ideas, especially because they're not just coming from the Heritage Foundation board. It's coming from. I'm glad you brought up John Eastman because one else may not know he was a CU faculty member at the time that he was going around corrupting the election results, and I don't think we have done enough reckoning with that. But
Not the law school.
yeah, not the law school,
Yeah,
but
that's right.
he was
We talked
a
about this.
CU Benson Center faculty member, so we need to own up to that. How do we challenge those kinds of radical ideas? I mean, the truly dangerous ones, when they're coming, again, not just from the sort of objectively far right people, but people that have a place in our own institutions.
Okay, well, first of all, what I don't want to see is paralysis. I think you guys have a voice. I think you have an important voice. If you got a petition to the university, they could, disavow them or whatever. I think there have been petitions, right? But use your voice also at another level, which is voting and organizing and saying people should disavow them. I no longer I used to go to the Federal Society all the time. When I was nominated to the Seventh Circuit, Judge Easterbrook loved it because I'm a sophisticated consumer of this stuff, right? But there are crazy parts, right? I mean, I can talk originalism all day long with my colleagues, but the crazy stuff scared me. That's why I talk about it. And that's electoral politics, but that is constitutional and it's legal too. It's not just something over in the political science department. So you need to make sure your elected politicians are pushing back on these people, pushing back on the ideas. Get them to commit what they'll do if they're elected to the House of Representatives about the court. There are lots of things that can be done with the court that aren't packing, by the way. You could revert, there's all sorts of moderate things that could be done if anyone had the will to do it. And get the institutions to disavow them. So the Federalist Society has not disavowed people, and so there's a new society called the Rule of Law Society, a bunch of conservative moderates who have disbanded themselves from the Federalist Society. So look around, start something on your own. Y'all have more energy than my vintage, but really it is up to you. And so you should think of it, I know it's scary, but it also could be exciting. You have a shot at this. All the doctrine is up for grabs. They want to get rid of scrutinies. They want to get rid of means and tests. I'm like, that's crazy, but they want to change everything. So you can have a shot at shaping it.
Thank you. Other questions?
And I will say we'll probably be hanging out at Chatham Commons for those. If you don't get your questions, come join us because we'll definitely want to continue this conversation.
Justice Breyer and Justice Scalia used to go on tours where they would debate each other about their respective interpretations of the Constitution. In reading Justice Breyer's books, I was impressed by the fact that he thought it was very important that judges in making their decisions are not just using a theory of constitutional originalism or living constitution, but it was appropriate to explore the consequences of the laws, their effect on. And what he said was that if the judges don't do that, the public will lose confidence in the courts and resort to an anarchy, and they'll take the law into their own hands. And it seems like what we have now is so much of a loss of credibility by the Supreme Court that they are no longer respected as following, being attentive to what the legislatures come up with in the course of their examination of questions that have a significant impact, particularly in the gun and the Second Amendment matters.
Yeah. Well, that's actually a really wonderful question, and it's got three really wonderful pieces to it. So, I don't see the justices going on tour together. I mean, they do speak at various events, but they have lost a lot of credibility. They used to come over to Georgetown. You know, we have light opera. We're the only law school with light opera. And Justice Scalia and Justice Ginsburg come over. We're in a new space. This is not Justice Scalia's court. That's the title of another article I've written. They are way beyond that. So you can I can go and give you what I think, and this is what Justice Barrett's trying to do. They created something called the Major Questions Doctrine. Have y'all heard about that? Yeah. And Justice Kagan says you just made that up to get out a text-free card, like that one. But Justice Barrett tried to at least reconcile it. She acknowledged that the other side was going too far, just as she did in the recent disqualification case. I wish, I've thought about bringing her over to Georgetown. But I don't think they're going to be doing that. I think it is dangerous to the extent they do not look at the consequences of their action. That's why I studied this in this article that's taken 2 years to publish. I read all the cases, then I coded them. I had 2 readers. I did it all the social scientific way. And then I actually did it the old-fashioned way. I searched for all the times they actually use the word consequences, because in their theory, they say they do not look at the consequences because that is policy making. They are just textual, robotic, I don't know. Lord knows what's going to happen if they use ChatGPT. But I agree with you. I think it's extremely dangerous, and it can happen in ways that you've already seen this. In this article, I talk about the Native American rights cases where everybody was very happy with a decision that affected Oklahoma, but it affected half of Oklahoma, which is a lot. And then it had an effect that no one really figured out at the time, because they're not policymakers, that it would bar prosecutions of things like child abuse because no one knew who was in charge. Because when you make big changes, they're going to have effects that you cannot see. So that's the even worse part. In a small case, maybe that's fine. In the end, I think they will have to wrestle with this. I called it self-hating consequentialism. They couldn't figure it out, but I'm really thinking about that, and I'm glad